by the 1899 award. Venezuela accepted the British proposal. On 16 November 1962, the chairman of the Fourth Committee noted the tripartite agreement to examine the documentary material on the boundary question through diplomatic channels. He concluded that there was no need for further debate within the UN. The tripartite examination was conducted by experts appointed by the parties. The United Kingdom reiterated that its purpose was not the revision of the frontier. It was intended only to dispel any doubt by Venezuela about the validity or propriety of the arbitral award. Between 30 July and 11 September 1963, the Venezuelan experts conducted an exhaustive examination of British documents in London. Subsequently, in November 1963, at the request of the Venezuelan Foreign Minister, Dr. Iribarren, meetings were held with the British Foreign Secretary in London to review progress. The ministers issued a joint communiqué. They declared that the next step would be for Sir Geoffrey Mead, the expert acting on behalf of both British Guyana and the United Kingdom, to visit Caracas to examine documentary material available in the Venezuelan archives. In December 1963, Sir Geoffrey traveled to Caracas to examine materials produced by the Venezuelan government. A British memorandum dated 25 February 1964 observed that the Venezuelan authorities have been unable to supply a single shred of evidence to support their contention of nullity. The tripartite examination was concluded on 3 August 1965 with the exchange of the experts' reports. The United Kingdom and British Guyana held that there was no evidence whatsoever to justify Venezuela's contention of nullity. But Venezuela continued to insist that the award was null and void. Irrespective of this process, by 1965, Venezuela began to issue official maps depicting so-called Guyana Essequiba as the Zona en Reclamación, territory to be reclaimed from British Guyana. One such map is in tab 3 of the judge's folder. Venezuela maintains that claim to this day. The sketch map at tab 4 of the judge's folder demonstrates that Venezuela's claim constitutes more than 70% of Guyana's territory. On November 1965, it was decided at the British Guyana Constitutional Conference that the date of independence would be 26 May 1966. The need to affirm the 1899 boundary became more urgent. The Guyanese feared that with the British departure, the Venezuelan military might invade and occupy the Essequibo region. It was agreed, therefore, that British troops would remain for some time to protect the new state's territorial integrity. In this context, between 9 and 10 December 1965, the ministers of foreign affairs of the United Kingdom and Venezuela met at the Foreign Office in London in the presence of the Prime Minister of British Guyana, Mr. Forbes Burnham. The meeting was in continuation at ministerial level of governmental conversations concerning the controversy in accordance with the joint communiqué of 7 November 1963. The first agenda item was an exchange of views on the experts' report on the examination of documents and discussions of the consequences resulting therefrom. The second agenda item was to seek satisfactory solutions for the practical settlement of the controversy, which has arisen as a result of the Venezuelan contention that the 1899 award is null and void. The United Kingdom Foreign Secretary, Mr. Michael Stewart, recalled that Venezuela's contention was aimed at the validity of the 1899 award. In regard to Agenda Item 1, he inquired if the tripartite examination had satisfied Venezuela that there was no substance in their allegations concerning the award's validity. The Venezuelan Foreign Minister, Dr. Iribarren, responded that the conclusions of the British experts' report were completely unacceptable. In his view, the only satisfactory solution of the frontier problem with British Guyana lay in return of the territory which by right belonged to Venezuela. Mr. Stewart clarified that Agenda Item 2 on satisfactory solutions could only be interpreted in the narrow context of the controversy over the validity of the 1899 award. He recalled that the 13 November 1962 British offer of a tripartite examination had made clear that any consideration of the substantive question of the frontier was out of the question. Given Britain's categorical rejection of the contention of nullity, Venezuela was eager to establish an agreed procedure for resolution of the controversy. To this end, Dr. Iribarren proposed a three-stage settlement process. The first would be a mixed commission to attempt a bilateral resolution of the dispute. The next would be mediation, and finally, there would be recourse to international arbitration. On 10 December 1965, the second day of the London meeting, the Attorney General of British Guyana, Mr. Sridath Ramphal, began by emphasizing once more that the agenda ruled out the question of discussion on the substantive issue of the frontier. He stated categorically that British Guyana could not accept that the 1899 award was invalid. Mr. Burnham, too, made clear that the territorial claim could not be at issue unless the invalidity of the 1899 award had first been established. Faced with this obvious deadlock, Dr. Iribarren once again focused on an agreed procedure for dispute settlement. Venezuela had come to the conference table, he explained, not to discuss positions already established, but in full consciousness of the necessity to reach a solution of the territorial problem. He emphasized that his own proposal for a mixed commission provided for finding solutions by a series of conciliatory stages, and if necessary, by recourse to arbitration by an impartial international body. Venezuela's willingness to submit to an arbitration tribunal, he added, represented a great concession on her part. Mr. President, Venezuela's memorandum of 28 November 2019 observes that an award is either valid or null. There is no middle ground. The validity or nullity of an arbitral award is non-negotiable. Guyana agrees, and that was exactly the position of the parties at the December 1965 London meeting. One side insisted on the validity and binding force of the 1899 award, while the other claimed that it was null and void. Faced with this impasse, they decided on 10 December 1965 that the discussions should be continued in Geneva in the week beginning 13 February 1966. Those discussions produced an agreed procedure for resolution of the dispute under the 1966 Geneva Agreement, which Mr. Reichler will now address. Mr. President, distinguished members of the court, that concludes my presentation. I thank you for your kind attention and that you call on Mr. Reichler.
I thank Professor Akavan, and I will now give the floor to the next speaker, Mr. Reichler. You have the floor.
Mr. President, members of the court, good afternoon. It is an honor for me to appear before you and a privilege to speak on behalf of Guyana. We take this opportunity to express our deepest wishes for your health and safety, and we thank you for protecting ours by allowing us to appear before you electronically. Mr. President, it is Guyana's contention that the court has jurisdiction over its claims in this proceeding, and that your jurisdiction is derived from two sources in combination. First, the agreement to resolve the controversy over the frontier between Venezuela and British Guyana, signed at Geneva on 17 February 1966, and second, the decision of the Secretary General of the United Nations, pursuant to Article 4.2 of that agreement, that the controversy shall be resolved by the International Court of Justice. I will address the first of these sources of your jurisdiction, the 1966 Geneva Agreement. Professor Pele will address the second source, the decision of the Secretary General. In between, Professor Sands will cover the period between 1966 and 2018 and the way the Geneva Agreement was faithfully implemented by the parties and by the Secretary General during that 52-year period in strict accordance with its terms. My presentation on the 1966 agreement is in three parts. First, I will review the terms of the agreement in order to establish their ordinary meaning in their context and in light of the treaty's object and purpose, consistent with the customary law principles codified in Article 31 of the Vienna Convention on the Law of Treaties. Second, after perhaps a coffee break, if the President deems that that is the appropriate time, I will call your attention to the negotiation and ratification of the treaty, including especially the contemporaneous statements of the parties as to its meaning. And third, I will compare Guyana's reading of the text with Venezuela's current reading of it, as set out in its memorandum of 28 November 2019, and demonstrate that Venezuela's current interpretation is erroneous, illogical, and completely contrary to the way Venezuela itself understood the same text in 1966 and for decades thereafter. I begin with the text of the 1966 agreement, which is at tab 5 of your judges' folders. The object and purpose of the agreement is reflected in its title. This tells us that it is an agreement to resolve the controversy between Venezuela and the United Kingdom of Great Britain and Northern Ireland over the frontier between Venezuela and British Guyana. The object and purpose of the agreement is further reflected in the preamble. Paragraph 5.